Before beginning, I would like to acknowledge the Butte College and its satellite campuses stand on the lands that were originally placed by the first people of this area, and we recognize and honor the Maidu, the Wintu, the Walaki, and the Nomalaki tribes. We thank them for their strength and resilience in protecting this land for centuries and aspire to uphold our responsibilities according to their example. In offering this land acknowledgement, we affirm the Native American sovereignty, history, and experiences. I also would like to honor this work in my presentation that is inspired by the rising of the Concow Valley Band of Maidu, who are able to find enough artifacts connecting them to their lands as a result of the fire of November 2018. Now, the Concow Valley Band of Maidu, who have been displaced for over 150 years, are now able to set forth in federal recognition. The process of gaining federal recognition as a tribe is a complex issue with significant implications for California Native American communities. Currently, several tribes in California are not recognized by the federal government, which limits their access to critical resources and services. There are approximately 110 federally recognized Indian tribes, including several tribes with lands that cross state boundaries. There are also about 81 groups seeking federal recognition. Like all other tribes around the country, California's tribes have a tragic history. Before the missionary, fur trapping, and gold rush era migrations, California Native American population was estimated at about 200,000. Between 1840 and 1870, however, that population declined to 12,000 due to disease, removal, and death. Between 1851 and 1852, 18 treaties were signed between the tribes and the United States. The treaties reserved 7.5 million acres for the tribes, but was rejected by the U.S. Senate in a secret session at the request of the state of California. The tribes, believing that the treaties were valid, relinquished all their historic territories, and they moved to the reserved acreage. However, once they reached their new locations, they were turned away. The tribes were not officially notified of the reason for this until 1905, some 55 years later. In the 1850s, California passed a series of laws pertaining to its Native American population. These laws allowed a justice of peace to remove Indians from lands in a white person's possession, and any Indian to be declared vagrant upon the word of a white person was thrown in jail and sold at an auction for up to 4 months with no pay. The kidnapping and selling and use of Indian children as slaves and indentured service of any Indian. One reported mentioned 110 servants who ranged from the age 2 to 50, 49 of them of whom between 7 and 12 years old. Prohibited Indians from testifying in court against white person, and in the 1950s, nearly 100 years later, the federal government continued to attempt forced assimilation on the entire Native American population. Over 109 tribes of federally recognized status were terminated of federal recognition throughout the United States. In California, this came about through the Ranchera Act of 1958, which resulted in another termination of 44 federally recognized tribes. The Relocation Act of 1956 provided funding to establish relocation centers for Native Americans in urban areas like Denver, Chicago, Los Angeles, and San Francisco, and to finance the relocation of individual Native Americans and their family. Funding for the similar reservation-based programs were denied. Those who participated in the federal relocation programs were usually required to sign agreements that they would not return to their prospective reservations to live. Between 60 and 70,000 out-of-state Native Americans settled in Los Angeles and San Francisco, and to date, these cities are the two of the largest urban Native American populations in the United States. And for the record, there are almost 400 unrecognized tribes in the United States. Tribal recognition, or the process by which the federal government formally recognizes a Native American tribe, has significant jurisdictional and economic impacts. From a jurisdictional standpoint, tribal recognition gives the tribe government-to-government relationships with the United States, which means they have a degree of sovereignty and self-governance. This includes the ability to make and enforce their laws, manage their own resources, and establish relationships with other sovereign governments. Tribal recognition also gives a tribe the ability to participate in federal programs and funding opportunities. The Indian Self-Determination and Education Assistance Act, also known as the Indian Self-Determination Act, is a U.S. federal law passed in 1975 that gave the American Indians more control over the administration of their federal programs, including education and social services. The goal of the act was to increase tribal self-determination and sovereignty, as well as to improve the quality and effectiveness of services provided to the Native American communities. The education assistance component of the act provided funding for tribal schools and allowed tribes to take over the administration of Bureau of Indian Education schools on their reservations. This gives tribes more control over the education of their children, including curriculum development and hiring teachers. Federal recognition can also make it easier for tribes to engage in these economic activities such as gaming, energy development, and tourism. Additionally, tribal recognition can help protect the lands and resources from outside development, which is particularly important for tribes whose cultural identity is tied to their land. The complex history of colonization and tribal displacement in California has made it difficult for some tribes to provide the documentation and evidence required for recognition. The federal recognition process involves extensive documentation and historical evidence to prove a tribe's continuous existence and political structure. The Bureau of Indian Affairs oversees this process and determines whether a tribe meets the criteria for federal recognition. The lack of historical documentation, political opposition, changes of federal recognition policies, and lack of resources are factors that can impact tribal recognition. Advocacy efforts can be directed at the federal government to make changes to the federal recognition process, providing additional resources, addressing historical injustices, and building alliances with non-tribal organizations. In recent years, several bills have been introduced to Congress to streamline recognition in the process and provide support for California's unrecognized tribes. For instance, the Tribal Recognition Act of 2021 would establish a commission to review and recommend tribal recognition petitions and provide resources to support unrecognized tribes in their effort to gain federal recognition. Several California and federal court cases have been related to tribal recognition, including the recent North Fork Ranchera of the Mono Indians versus the State of California case. In this case, the North Fork Ranchero tribe sued the State of California for violating the Indian Gaming Regulatory Act by refusing to enter into a compact with the tribe for casino gaming. The case centered around whether the tribe was eligible for gaming under federal law, which required them to be recognized by the federal government. The tribe won the case, and the decision affirmed that the importance of federal recognition for a tribe's economic and social development. Addressing historical injustices, building alliances, and providing additional resources to unrecognized tribes can help tribes navigate the recognition process and access critical resources and services. Advocacy efforts can be directed at the federal government to make changes to the federal recognition process, including changes to the criteria used to determine tribal recognition. Oklahoma is a state with a different approach. The Streamlined Recognition for Oklahoma Tribes Act is a U.S. federal law passed in 2020 that established a simplified and expedited process for certain Native American tribes in Oklahoma to gain federal recognition. Previously, the process for obtaining federal recognition was lengthy and complex, requiring extensive documentation and historical evidence. The Streamline of Recognition Act streamlined this process for tribes that had previously been recognized by the state of Oklahoma and could demonstrate their continuous existence as a community since 1900. Under the new law, eligible tribes could petition the Bureau of Indian Affairs for federal recognition by submitting a letter of intent providing supporting documentation. If the petition was approved, the tribe would be granted federal recognition and would be eligible for federal benefits and services. The Streamline of Recognition for Oklahoma Tribes Act was seen as a significant step forward for these tribes, many of which had been seeking federal recognition for decades. It was also seen as a recognition of unique history and cultural heritage of the Native American tribes in Oklahoma, which faced significant challenges and discrimination throughout their history. In conclusion, addressing the lack of federal recognition for tribes in California requires a multifaceted approach that considers the unique historical and cultural factors of each tribe. It is crucial to provide support and resources to unrecognized tribes to navigate the recognition process and access critical resources and services. Thank you for listening.